I'm Bernie Musry. I'm a solicitor specialising in litigation and construction litigation. And joining me today is Mr. Andrew Clark, a long-time friend and something of a mentor for me over the years. So I'm very pleased to have him today.
Good to be with you today, Bernie.
So welcome. And this is the Caselaw Club. All right. So today we have the matter of the Taringa Group Proprietary Limited and Kenik Proprietary Limited, 2024 case, the Queensland Supreme Court, number 327 of that year. And this is quite an interesting and a bit of a landmark decision, actually. It's around a payment claim that's been made and an adjudication that has occurred after the fact. But let's start at the beginning. So we have a developer, Taringa Property Group, Proprietary Limited, let's call them Taringa, and they've contracted to build a retail outlet with a builder, a contractor called Kenik Proprietary Limited, let's call it Kenik. So they've signed a contract, a design and construct contract to the tune of 13.6 million, little on the cheap side if you ask me, but who knows? We don't have the plans in front of her. Now, it was common ground between the parties that the contract did overrun its time. And because it overran its time, it's unclear on the face of it how much responsibility is distributed to the various parties as to that overrun. But because of that overrun, there's a significant additional payment claim that's been made. On the 8th of September, Kenik has made a final payment claim for $9,680,767.44. That's including GST. But shortly on after that, Taringa responds by providing a payment schedule, and what do we expect? It's nil, zero to be paid. So, of course, it naturally flows on to adjudication, and the adjudicator finds in favour of Kenik, but not in respect of the full 9 million. The amount comes to something like $4,218,087.02. 7 days later, Kenik obtains a judgment debt. So that's 21st of February 2024 at this stage. So there is an ongoing dispute, and because of the nature of this judgment, because of exactly how this judgment is written, it's a little bit, the way it's described is a little bit tricky. It appears that there's a preliminary decision that knocks out some of the grounds, and then there's a stay waiting on further grounds to be heard. And the original application, the originating application, comes with an application for a stay. So Taringa doesn't want the adjudication sum to be paid to Kenik, and they seek a stay. And that's what stayed. And the judge then, after the decision to knock out some of the grounds, it appears to me that they returned to consider the stay. And the court has at least turned its mind to whether or not there might be an appeal, although they're the ones who have knocked out the preliminary ground. So it seems to be at least a partial finding for Kenik.
Yes, so the finding in favour of Kenik, the first there's two findings in favour of Kenik. The first is by the adjudicator, saying they're entitled to approximately $4.2 million of the amount claimed in the payment claim. The second finding in favour of Kenik is when the adjudication award is recognised as a judgment debt immediately due and payable. That is probably an unsurprising outcome. It is relatively rare that a properly rendered adjudication decision would not be converted into a judgment debt in favour of the contractor who has succeeded in an adjudication. Typically, that would only occur where a jurisdictional error can be proven by the respondent to the adjudication application. and a contention that the adjudicator got the decision wrong doesn't rise to that level. So we see Kenik succeed in obtaining a judgment debt, and that is why Taringa is forced to do two things. Number one, to commence a substantive proceeding to essentially overturn the adjudication decision, and that's in essence a de novo hearing of the subject matter of the adjudication. And the second and the key issue in this judgment that we're considering today is they seek to obtain a stay on Kenik's ability to enforce that judgment debt they've succeeded in obtaining.
So that seems to make sense if the prior proceeding is a separate proceeding.
Yes. So we see references we see references in the judgment to TPG or the Taringa, the developer, opposing the judgment debt being recognised, but we don't see much in this judgment about the reasons that were advanced that the judgment debt shouldn't be crystallised, and I don't see that anything in this judgment really turns on those reasons, on those arguments.
No, I think the judge, we might turn perhaps to the judgment to get a little clarification on this, because it is sort of a tricky situation with multiple hearings in the Supreme Court.
Yes, so at paragraph 5, we see the reference to Taringa's efforts to have the adjudication decision in effect nullified or declared void in whole or part as a consequence of alleged jurisdictional error.
On the 23rd of February 2024, TPG, that's Taringa, filed this proceeding seeking to have the adjudication decision dated the 14th of February 2024 made by the second respondent pursuant to the Building Industry Fairness Security of Payment Act 2017, Queensland, BIF Act, in the identified sum in favour of Kenik declared void in whole or in part as consequence of alleged jurisdictional error. Related relief was also sought. So that's the initial proceeding.
Yes, that's TPG's opening salvo and an unsuccessful salvo for them in trying to avoid paying the sum awarded in the adjudication or determined in the adjudication rather to Taringa.
What I'm confused about is it says filed this proceeding, right?
Ah. Yes, that is curious.
The procedural history of this case is a little bit complicated. There's some nuance and there's perhaps a couple of possible wrong interpretations. My personal wrong interpretation was perhaps that this was indicative that the claim wasn't knocked out in its entirety. If they sort of stay alongside the application, they've said, okay, no, well, we're not going to allow this to be challenged on the basis that the adjudication was incorrect. I think the court does say something along those lines, that this court affirmed the adjudication.
It wouldn't be unusual for an interlocutory matter like a stay to be determined separately, as part of a larger proceeding and a separate judgment being rendered, in relation to what is formally the same proceeding. But for the purpose of this judgment relating to the stay, nothing turns on the question of whether or not there was jurisdictional error, and
no,
we can assume in our consideration of this matter is that no jurisdictional error was established.
Although it's quite an interesting one, because if, let's say, so we have an original application. The application includes a stay, right? The stay is adjourned until they decide the substantive matter of the dispute, which would make sense, because why would we make a decision based on the stay, whether it could be enforced, before we've considered whether there's grounds to appeal?
We've got to be careful when we refer to the substantive matter, because
the substantive matter of this decision.
The substantive matter of the whole claim is Taringa's, claim for the recovery
Yeah.
of the amount awarded
So
and the
paragraph
final
8.
determination of the parties' entitlements.
That's right. Paragraph 8. Taringa submitted in this proceeding that the decision is void for jurisdictional error on 4 alleged grounds. So that's the standard matter of the original hearing. In a decision dated 6th of December 2024, I rejected those arguments and I found that the decision was valid. So it's been affirmed, or at least on those grounds, on 4 alleged jurisdictional errors grounds, it's been affirmed. Accordingly, I dismissed paragraph 2 and 3 of Taringa's originating application. There's not yet been an appeal for that decision or any indication that an appeal is to be filed. So the court's saying that they're not seeing an appeal, but they're turning their minds to it. They're considering that it might well occur. And it seems to me possible that it's been foreshadowed somewhere in this case. Let's hammer through the rest of the facts. No, all right. So all right. To summate what we have so far, we have the original application. The application seeks both a stay and jurisdictional error on jurisdictional error grounds. The appeal of the the adjudication decision. Then we have that adjudication decision confirmed, and then we have the court revert to the stay. And what's really fascinating about this is, well, I'm getting ahead of myself. All right, let's jump back. Okay, so it should be noted also that Taringa pays the full amount of the adjudication sum, I believe, plus interest. Plus an amount for interest. We should quote paragraph 7. A decision TPG paid into the court pursuant to orders dated 29th of February 2024. So they were ordered. The sum of $4 million, $825,708.11 in respect of the adjudicated amount plus an amount for interest and adjudication costs. So they've paid into the court. So they've got security there. And then we turn to the substantive question of whether a stay should be awarded. And I found this absolutely fascinating because this appears to be an entirely unique case, at least in Queensland and possibly outside of Queensland too. I'm not sure how many states it applies to, but it seems to be quite an interesting case.
And we might just note for the construction law practitioners in other states that aren't familiar with Queensland. In Queensland, it is not referred to by the practitioners as SOPA, as it is elsewhere in Australia. In Queensland, my Queensland colleagues refer to it as the BIF Act.
BIF Act.
But in brackets, security of payments. So when we refer to the BIF Acts, for those that aren't familiar with Queensland practice, we are referring to a piece of legislation that you would know in any other state or territory as SOPA.
Yes. Well, it has security of payment in the name. It's the Business Industry Fairness Security of Payment Act. Surely our colleagues will be comfortable using some foreign terminology. Hopefully you will. All right. So, I mean, the reasons to grant a stay or not to grant a stay, consequently, are rooted deeply in security payment or the BIF legislation. And I think the history of that is it was brought in to prevent insolvency in builders and in contractors, where principal builders were withholding payment to compel, let's be nice about it and say, contractual behavior. The result of that is businesses were going under substantial harm. And
the employees of those businesses and the subcontractors of those businesses having their their livelihoods and financial challenges flowing from that. And in very, very actually a building project doesn't have to be that complex for the chain of subcontracting chain, run 4, 5, 6 businesses deep, and all those businesses have their own suppliers and employees.
I mean, even just in a single person, in a home, in a domestic dwelling, let alone an entire shopping centre, you have the builder. Then you have under them, you probably have a bunch of the builder's employees who are going to pour structural components. Then you have people who are going to paint, electricians, plumbers, fit out people, finishing trades. You have roofers. You have a ton of different subcontractors, and that contractor not being paid if they're unable to fill their obligations to those subcontractors as well as a result of that, that's a tremendous chain of failure. You're very kind to turn your mind to how many people are being impacted. I just sort of see big numbers. But yes, aside from economic impact, it's tragic. It's tragic that it's constant. But so it's designed to protect us against that by keeping construction companies solvent. So because of that, it's sometimes described as a pay now, argue later system.
Yes.
So the obligation is to pay, adjudication is done, it's time limit. I can't recall off the top of my head. I think I do, but I don't want to quote it because it could well be wrong. Too many states with different time periods.
Indeed.
But it's something on the order of 2 weeks to 20 days. And so it's very, very fast.
Yes.
And the result is that there's an obligation to pay. The obligation to pay supersedes a bunch of other things. So, yeah, very strenuous, rigorous obligations now supplemented by the trust obligations that builders and construction entities will incur. But I think that's a matter for another day. The general policy is to pay quickly and not to overthink this. So what do? We have to move. The starting position of the court is that they should have to pay quite quickly. The court considers this. They consider a bunch of different factors. I might quote from the judgment, paragraph 16. Considerable caution should attend to the grant of the stay, as to grant to stay detracts from the primary purpose of the BIF Act. That is a sentiment that has been expressed in decisions of the New South Wales Court of Appeal, yet I mentioned, in particular TFM Epping Land Proprietary Limited Beacon. I think I recall that case. And let's skip forward a little bit. Paragraph 17. The prima facie position, given the policy objectives evident in the BIF Act, is that in the ordinary case, stays are not granted. The BIF Act is designed to improve cash flow for contractors, and any risk of non-recovery of payments made under the BIF Act as a consequence of financial failure of the contractor after the receipt of the BIF payment is generally to lie with the principal or superior contractor required to make the payment.
This policy assumption arises, I think, from the presumption baked into the Act is that generally ultimate principals and principal contractors tend to have more substantial balance sheets than the subcontractors that they engage. On very large projects, we see from time to time that doesn't necessarily hold true. You know, large specialist contractors, often with international backing in the engineering space, will often have more substantial balance sheets than domestic contractors. But that is not the assumption that's baked into the Act. And I think that's because the assumption that's baked into the Act is that this legislation will be engaged far more commonly on smaller and less complex projects than larger projects. Now, whether that's borne out in reality, we'd have to get the statistics from the appointing authorities in the various states, but generally done for the benefit of small players where a singular payment delay could have substantial ramifications for the solvency of the business as a whole.
So Kenik, being as it was that they were arguing against this, took the court's sort of high standard for an application for a stay, whether a stay should be approved. But by the way, there are some existing examples of stays being given in situations where the claimant is in liquidation. Or I think I'm not particularly sure of the case. I think it mentions it in this case, but don't quote me. There's the potential for it to be restructuring to change the way in which that entity is answerable to its debt. That was my preliminary reading of it. So,
yeah, there's a recognition that a stay will be appropriate in two circumstances where the contractor is making an effort in restructuring their financial affairs to make recovery of that interim payment more difficult, or where that contractor is seeking to delay the final determination such that the interim payment cannot be recovered in a timely manner. But the judgment in this case is clear that there's no suggestion that Kenik was behaving in any of those behaviours, and I don't understand from the judgment that Taringa ever alleged that.
No, but it was interesting because they sort of come close to one, don't they? Kenik is beyond dispute very close to insolvent trading, and who knows? Maybe they've crossed the line, or they're at risk of crossing the line, depending on the outcome of this judgment.
Well, certainly, Bernie. What was clear to face the judgment in this matter is that there was evidence that Kenik's liabilities exceeded its assets by some margin. It was also recognised in the judgment that Kenik no longer possessed its builder's licence in the state of Queensland, and the judge observed that Kenik did not appear to be trading in any meaningful fashion, or perhaps at all, and that's there at paragraph 37.
Paragraph 37.
It is also known that Kenik is otherwise not trading. It has given undertakings in different proceedings to that effect in June 2024 to prevent further debts from being incurred. There is therefore no obvious source of further income/assets. In fact, the director of Kenik, Mr. Kennedy, has been personally funding Kenik so as to manage its cash flow problems whilst it awaits the outcome of this proceeding. Now, that's interesting because Mr. Kennedy seems to have put himself, in the shoes of, or in a similar position to a administrator and creditors, in that he is putting the organisation in funds for the purpose of carrying on legal proceedings to improve Kenik's financial position. We don't know Mr. Kennedy's reasons for doing so. Two possibilities are that Mr. Kennedy is a substantial creditor to Kenik. Another possibility is that Mr. Kennedy, in his capacity as a director, has given substantial personal guarantees to contractual counterparties of Kenik, and so reducing the extent of Kenik's financial difficulties might well have, financial benefits for him personally.
It was important to note we were speculating.
Yes.
But I think the second of those suggestions is highly likely without knowing the given facts of the situation. It was very, very common.
The name Kenik sounds awfully like Kennedy. but yes, if Mr. Kennedy is personally funding Kenik, it suggests that there is some interest there, although we don't know the nature of that interest, and I don't think it matters for the present proceedings what his interest is.
Possibly. I mean, he's the director of the company, so that's an interest inherent. But the secondary possibility I would suggest is that the sort claim is $9 million, and they state later on, quite directly, paragraph 38 starts on the other side of the ledger. There are liabilities of nearly $7 million, so $7 million in liabilities, and the progress claim is approved $4 million and requested $9 million. Now, if they were to recover the full $9 million, then they'd be not only trading solvent, they'd be pretty happy campers, I would think. So there is perhaps a business interest without volunteering personal assets converging, that sort of thing. It's possible. It's hard to say because we don't have the precise facts that matter. But it's, again, interesting speculation. All right, so skip to the ending. The court chose to grant the stay. They said yes. And funnily enough, shortly after that decision, there was a decision, another matter filed, matter of Barrett Group Proprietary Limited and Kenik Proprietary Limited, 2025 case of the Queensland Supreme Court, number 25, where lo and behold, Kenik was wound up by creditor action. I think there's an acknowledgement that if this judgment wasn't going to be successful, they were going to be wound up anyway. And there's a conversation around the loss that would be incurred if the money is transferred and that money goes to satisfying other debts, and the money is gone. It's kaput. And if the company isn't trading, this is an unusual case because the company has stopped trading. What prospects is there of recovering from insolvent trading if recovering from recovering before they hit insolvent trading, let's say, if they're not trading?
Well, the judge in this matter observes very, very, very poor prospects for Taringa to ultimately recover those funds if it is successful in the final determination of the matters, and that is the compelling rationale for the grant of the stay in this matter.
Very compelling, and a highly unusual case. You're going to see how it's reached this position, but because it is unusual, because of the factors which are involved, and because of the particular financial situation, both of the parties and the amount that's been paid into the court already, so security on hand, there's a number of factors. But because of all of that, we have a new situation in which we can have a stay to BIF, SOPA applications. Very fascinating. Thanks for joining us, everyone. This has been Caselaw Club.